Okay, I think that we are recording. In last month's webinar, we covered code compliance for landlords. That is obligations that landlords have. This month, we cover landlord rights, what landlords are entitled to do. We'll be discussing residential properties. Just to give you a little bit about my own background, I'm the owner of High Fidelity Properties. We're a residential property management company. I have been in property management for 15 years and I own rental properties myself. And then just a little bit about my company. We're 10 years old. Our portfolio consists of single family homes, duplexes, fourplexes, and condo units. And we currently manage 120 doors. We cover the full gamut of property management services and also offer a bunch of extras. And then just a quick disclaimer, I am not an attorney. As you know, I'm a property manager, so I am not interpreting the code here. I'm just simply sharing it with you. If your clients have any questions about what to do, they should definitely consult an attorney. And something to note in general is that many of these code clauses have exceptions, but we can't go over every exception. So I'm providing the basic code, and landlords wanting to seek remedies should get legal help. The sources that I'll be using today are the Texas Property Code, Chapter 92 in particular, which is about residential tenancies, but I'll also refer to Chapter 24, which covers evictions, and Chapter 54, which covers landlords' liens. Allison is going to put links to downloadable PDFs for all of these. I know you love this kind of reading. The Texas A&M Real Estate Center puts out this great 125-page document, Landlords and Tenants Guide, that helps make sense of the property code and the laws. And then there's the Texas Realtors Lease TXR 2001. If you're helping your clients, I recommend using this lease. You can be sure it follows the law, plus it's landlord friendly, and it's pretty comprehensive. Many of the rights that we'll be discussing are laid out in the Texas Realtors lease. If you're not using this lease, your rights may vary. Many clauses in this lease reference the landlord rights as outlined in the Texas Property Code. But this lease gives additional rights to landlords that are not expressly forbidden or addressed in the code. For example, Chapter 92 doesn't address pets, but the lease does. That doesn't mean you can add any old clause that you want, but I'm just explaining what's going on here. And I just want to take a moment to share some perspective. There are rights, and then there's doing the right thing or what's expedient or effective. Some landlord rights may seem harsh, and maybe they are, but there are appropriate times to assert those rights. Other times, asserting one's rights won't be the most effective way to actually get what you want. In addition to this, something to remember is that tenant happiness is exceedingly important when it comes to successful landlord-tenant relationships, having tenants renew if you want them to, getting good online reviews, and so on. Being in the property management industry for 15 years, so much of what we do is strategy, negotiation, and diplomacy. I think it's important to keep that in mind. Something really interesting, by the way, is that when you do a Google search for cases that landlords won against tenants, the bulk of the results that come back are about tenants suing landlords. Interesting bias or interesting reality. Notable, though, is that landlords win the vast majority of eviction cases. So that's good news. This particular presentation is about what landlords can do. So here we go. We're going to start at the beginning of the process, namely finding tenants. And first, we'll have a poll. Can landlords ever discriminate when choosing tenants? It's just yes or no. It's totally anonymous. So, great. All right, only about half of you have participated so far, but again, it's totally anonymous and nobody will know what answer you gave. All right, we seem to have stalled out here on people willing to give answers. So we'll go ahead and we'll end the poll and we will share the results. So a slight majority of you think that no, you can never discriminate. And the answer to the poll is yes, there actually are cases when landlords can discriminate. We're all familiar with fair housing laws, but there are two exceptions that allow landlords to discriminate. The first is an owner-occupied building with no more than 4 units. And the second is a single-family home rented by the owner without the use of an agent. But if you're helping them with leasing, you must follow fair housing laws and you can't allow your clients to discriminate. Let me say too that I'm only talking about protected classes covered by the Fair Housing Act. Outside of that, you can actually discriminate in all sorts of ways. For example, if you don't like lawyers, you don't have to take them. If you don't want a realtor or a property manager living in your home, you don't have to take them either. That's of course, as long as they are not covered under other aspects of the Fair Housing Act. When doing a background check, HUD says that in the majority of cases, criminal history can't be factored in because it has a discriminatory effect. But there are 2 cases where you can outright turn down an applicant and you can have that in your written rental criteria. Sorry. Okay. One is conviction for drug manufacturing, and the other is for conviction for drug distribution. There are likely some others, but that would be a time to consult an attorney. We process hundreds of applications every year, and we see all kinds of things. I'll get the question, hey, this one has a DWI, do we reject them? Nope. This one was caught with pot, do we turn them down? Nope. This one wrote a bad check, does that count as a rejection? No, no, no. Most cases, we just can't factor these things in. One last thing about applications is that in Texas, we don't have to accept housing assistance, Section 8. This is not true in a number of other states, by the way. Now it is time for our second poll. All right, do landlords have to accept cash as payment for rent? All right, we still don't have everybody yet. If anybody else wants to weigh in. Okay, we're going to go ahead and end this poll, and then we'll share the results. So the vast majority of you say no, that a landlord is not required to accept cash as payments. And you are correct. The answer is no, as long as the lease specifies this. The Texas Realtors lease lets you check off the form of payments you'll accept, as you can see here, and cash on this one isn't even an option. By the way, going forward, the numbers such as 5D3 refer to the paragraph of the Texas Realtors lease. And the longer numbers such as 92.0081 refer to the Texas Property Code. You can also specify if tenants have to pay rent in one payment each month or if multiple payments are okay. And if you're wondering why you might choose one or another, you might allow multiple payments because there are multiple tenants, and if they're paying online, who cares as long as you get all your rent? You might not because you find it a nuisance or because it's possible that if partial rent is paid, it might affect an eviction proceeding. That actually could be true, and that could depend on the judge. We allow our tenants to make multiple payments, by the way. Rent has to arrive by the due date, not be in the mail or postmarked by the due date. This includes holidays and weekends, so it's on the tenant to factor in those things when mailing in a check. Our tenants pay rent online and they can set up an auto debit, so this makes it a non-issue for us, and it's a great way to go. Recommended if your clients can do it. Application of funds. The landlord can apply rent to non-rent obligations first before applying it to rent for things such as late fees and pet fees, utilities, NSF fees, and so on. For example, if the rent is $2,000 and they pay you $2,000, but they owe you $100 in late fees and $50 for utilities, you can pull $150 to cover those fees, and then the tenant has only paid you $1,850 in rent. If they don't then pay the remainder by the due date, you can actually start charging late fees because they are now short on rent. Tenants, of course, hate this, but it's actually quite explicit in the lease. If the tenant renews or the lease goes month to month, You can raise the rent with a 30-day written notice. It must be written, by the way. There is no limit to the rent increase you can make, but that doesn't mean that the tenant will renew at that rate, but you can try. Just remember though, that keeping a tenant is way less expensive than finding a new one. So you don't necessarily want to shoot yourself in the foot by getting a little greedy. We have a client in California who owns 5 single-family homes in Austin. Tenants in one of them reached out early and said they would love to renew for 2 more years. This is great. This is a real boon for the client to have a tenant want to be there for 2 more years. We don't normally actually contact clients about renewals. We just do them. But since she's about to sell one of the other houses this season, we wanted to check to make sure she'd be keeping this particular home before agreeing to 2 years. So when we reached out, we let her know that we'd be raising the rent by $100. The owner came back and said she wanted $200. Because she lives in California, it was clear to me she didn't really realize that $200 is out of whack for Austin. Plus, it comes across as penalizing the tenant for wanting to stay a long time. We asked the tenants anyway. Of course, they said no, but they were willing to do $100, which of course is what we ended up doing. Okay, late fees. If rent is past due for at least 2 days, but it must be 2 days, you can then start charging late fees. There are limits to the late fees though, and a lot of people actually don't know this. For a property with 4 units or less, you can charge a max of 12% in late fees. For a property with more than 4 units, it's 10% max. Okay, now it's time for our third poll. And this one is a scenario. This one is actually fun to watch as the answers come in because it's like switching back and forth. It's really interesting. All right, we still have a few people who haven't. Any other takers for the poll? Okay. All right, so in this case, it was pretty close, but we have a slight leaning towards no, that the landlord cannot deny the animal. And the answer is no. You can't deny a service animal, even in that scenario. So in that scenario, the landlord would want to discuss it with their insurance agent and see about getting some type of waiver, or else they should change insurance companies. Other than support animals, landlords don't have to accept pets. Austin is a super pet town, as we all know, so a landlord may drastically reduce their tenant pool, but that's up to them. You
But
can't.
it says emotional. It's not, doesn't say that the service animal.
I'm sorry?
I thought the question says the emotional service pet. It's not the service animal, you know, there's a difference, I guess. Is there?
Well, okay. I mean, that sort of brings up a whole topic unto itself. And what would actually be great is if you can put your question in the chat box, because that kind of could be a longer discussion. And then we can talk about support animals or service animals. Okay. All right. So you can charge violation fees if somebody has an unauthorized animal. In fact, you can charge hefty fees for that if you want. The Texas Realtors lease allows an initial fee and a daily fee until it's resolved. We do an initial fee of $500 and a daily fee of $100. This is our way of getting tenants to move really quickly to get their animals qualified and on a pet agreement. We had a case where it turns out that the tenants had a dog, 2 guinea pigs, and a snake, all unauthorized. We had done an inspection and that's how we discovered them. When all was said and done, the tenants paid over $1,000 in deposits and violation fees. If they have an unauthorized pet, the landlord can actually cause them to be removed. It's maybe hard to imagine separating a pet from their human family, but the ability to do so is there. And there certainly could be valid reasons for it. For example, if the landlord is planning to move into the house someday and they're highly allergic to cats. You can charge a pet deposit. A deposit by definition means that it's refundable, but you could instead and charge a pet rent and a pet fee. A fee is not a deposit, so you can make it non-refundable. So for example, pet rent would be something charged on a monthly basis, maybe 10 or 15 bucks a month. And a pet fee is something that you would collect up front, likely, and then that would be a fee that you keep. Okay, repairs. So tenants can't withhold rent for repair issues that don't affect health or safety. We certainly recommend making all needed repairs, but the point is that the tenant has to pay full rent. Occasionally, our tenants threaten to withhold rent if a repair isn't done super fast. In those cases, we just share the part of the code that shows this is not allowed, and typically that's the end of that. If a tenant is delinquent on rent, the landlord doesn't have to make the repairs unless it materially affects the tenant's health and safety. So this can be an incentive for a tenant to go ahead and pay full rent so that they can get those repairs done. A tenant is not allowed to make repairs themselves. Only the landlord can authorize that. So if a tenant were to make a repair that isn't authorized, a landlord would not be obligated to reimburse them. There are, of course, some exceptions to tenants making repairs, but that's a landlord who's really not taking care of business. So we've just been talking about general repairs, but I'm sure many landlords had questions after last month's storm. So let's dig into that. In our portfolio of 120 properties, 20 had some damage due to the storm, and of those 20, 12 of them related to the pipes. In one case, it killed the tankless water heater, and there was a shortage of water heaters, as you can imagine. So that took a couple of weeks to fix. There were also a couple of cases of condo units where whole buildings lost water, and there was nothing we could do about it since that's on the condo association. Okay, it's important for tenants to know that they have certain obligations to protect the home they live in from adverse weather events. Paragraph 17 states that the tenant at their expense must take all necessary precautions to prevent broken water pipes due to freezing or other causes. So that means they had to wrap the exterior pipes, run the faucets, and open the cabinet doors. That same paragraph also states that they must know the location and operation of the main water cutoff valve and all electric breakers and how to switch them off at appropriate times to mitigate any potential damage. Before the storm, we sent a long preparatory email letting them know what to do. And then during the storm, we were actually very concerned that once the pipes thawed, that we would have floods everywhere. So we actually called every single one of our tenants to check on them during the storm and also to make sure that they knew where the shutoff valve was and to provide instructions as needed. In order for a landlord to repair a condition, the tenant is required to notify the landlord of that condition. Seems basic, but if the landlord doesn't know about it, they can't fix it. You know, these requirements are important because if tenants don't take necessary precautions and there is damage that can be attributed to their negligence, the landlord may have recourse to charge the tenant for the repairs and possibly to evict for breach of lease. Your client should definitely speak to an attorney if something like this should happen, especially if the damage is significant enough and it could affect their insurance rates. At the point that the landlord has been notified, they have 7 days to make a diligent effort to repair the issue unless another time frame is needed. For example, if you can't get parts, which was definitely an issue after last month's storm, I mentioned that about the tankless water heater, or say there are no utilities on. If it's an insurance claim, the landlord doesn't have to make the repairs until the insurance proceeds have been received. If the home becomes completely uninhabitable, either the tenant or the landlord can terminate the lease. Regarding renter's insurance, the Texas Realtors lease recommends it and explains why in the lease, but it doesn't require it, but your clients totally should. Landlords are not responsible to cover a tenant's personal property, and they also have no obligation to cover hotel expenses. So a tenant can be protected by having renter's insurance, and that can also help to protect the landlord-tenant relationship because they'll have some recourse. We did actually have a tenant try to get us to pay for their hotel after last month's storm, but we directed them to their renter's insurance. In the end, I don't know if they contacted the renter's insurance or not, but they stayed at another family member's home. So speaking of liability, generalizing this topic beyond this particular storm, the landlord is not responsible for damage, losses, or injury due to all types of weather events, fire, interruption of utilities, crimes, environmental contaminants, unless these issues were caused by the landlord. For example, mold could potentially be caused by a landlord if they knew of an issue and they didn't take care of it. Okay, now we're going to go to our fourth poll. When a lease term is up, can a landlord terminate for no reason at all? All right, any other takers? Okay, here are the results. You guys are good. The answer is yes, a landlord can terminate the lease at the end of the lease term for any reason. There is no requirement in Texas to renew. You must give a minimum of 30 days written notice. It might be longer based on what's in your lease. We do 60 days. I'm going to share a crazy story that happened to us recently. We've had a tenant in a property for 2 years, and she has struggled to pay rent for the entire duration of COVID. The owners agreed to a rent concession for most of that time, which was really nice. And we also agreed not to charge late fees, and we worked with her on getting rent. She did make efforts to find money from various sources, and she pretty much got caught up. But even a year later, she's still not earning a regular sufficient income. And frankly, the rent has just simply become too high for her. So when her lease was going to be up, we gave her a 60-day notice of non-renewal. She was shocked. She totally didn't see that coming, which actually surprises me a bit. And she felt that we were being ungrateful after all of her efforts to pay rent, as if she was doing us a favor rather than fulfilling her most basic obligation. She insisted on being able to speak directly to the owners, which we would never do, but she tracked them down anyway, and she showed up at their front door. She tried to cajole them, and then when that didn't work, she mentioned that she now knew where they lived. It completely freaked out the owners, and to give you an idea of how much, after she was gone, they called the police to see if they had any recourse to keep her from coming back. Once she understood that it was the owners just as much as us who didn't want to renew her lease, she let it go at that point, and she is moving out next week. This is a perfect example of when you know you made the right decision to not renew a lease. Okay, moving on. If a lease is signed, but the tenant doesn't move in and the deposit is not collected, a tenant is nonetheless liable under the lease once signed. You may not bother to enforce it, as it's likely quicker and easier to just move on. Security deposits. The landlord can put the security deposit in an interest-bearing account, and they can keep the interest. In some states, the interest actually has to go to the tenants. The landlord can keep the security deposit after move out for up to 30 days, but no more, assuming a forwarding address has been received. If it has not been received, then the 30-day clock starts once the forwarding address has been received. A tenant has to pay last month's rent. They can't say that the deposit will be used for that. In fact, the tenant could be liable for up to 3 times the amount wrongfully withheld and attorney fees if you went after them. A landlord can deduct from the security deposit for damage, of course not normal wear and tear, for cleaning, deodorizing, smoking damages, unpaid rent, late fees, utilities, unreturned garage openers, keys, light bulbs that are out or missing, and removal of property left behind. There's some other items, but those are the main ones. Tenants get especially peeved when money is withheld from the security deposit, so landlords may want to take care to be fair and reasonable. Some other rights that a landlord has: a landlord can limit how long guests can be there. We put in 7 days. If a guest stays a long time, they could potentially be considered a tenant, and you may want to go ahead and put them on the lease and make them responsible too. That's good for you as the landlord. A landlord can prohibit short-term rentals, and they really should, because that could be disastrous for the condition of the home. The landlord has the right to access the property for all sorts of reasons: showings, inspections, emergency repairs, fire marshal, to leave notices, exercise a lien. It's a good idea and a courtesy to notify a tenant that you're coming, but in the lease, notice is not actually required. When you might not want to give notice would be if you're trying to do a surprise inspection, maybe suspect drugs or something like that. A tenant can pay not to have a lockbox at the property, but the landlord still has a right to show the property to prospective tenants. In that scenario, the agent would have to coordinate with the tenant and be let in by the tenant, or maybe the landlord or the property manager. We set that fee very high so as to deter tenants from taking us up on it. In the case of holdover, in other words, if the tenant doesn't leave at the end of the lease, the landlord is owed rent during that time. And rent is 3 times the monthly rent, which you calculate on a daily basis and is due on a daily basis. We just this week had a tenant tell us that she is planning to stay beyond her lease, which ends March 31st, even though we gave her proper notice. We'll see how this one plays out. This is a property and a tenant that we inherited a few months ago, and she has not been good about paying her rent, so it seems pretty unlikely that we're going to get 3 times the rent. The tenant can't sublet without the landlord's permission, and if the landlord does allow it, the replacement tenant has to be approved by the landlord. You can also charge a fee for early termination, and the tenant is still on the hook for rent, utilities, lawn, and other expenses until a replacement is found. Per the property code, occupancy is limited to 3 times the number of bedrooms. So if someone had more family members than that, you could say no. There are some exceptions to this, but they don't come up often. All right, default and evictions. As mentioned, evictions are covered under Chapter 24 of the Property Code, and Allison will go ahead and drop that link into the chat box. I'll start by covering evictions in regular times, and then we'll cover evictions during COVID, since I know that's a hot topic. 27B says that a tenant is in default when they don't pay their rent or they otherwise fail to comply with the lease. In those cases, the landlord can evict for breach of lease, or the landlord can exercise the landlord's lien, which we'll talk about in a bit. The tenant is liable for all costs associated with reletting the property: eviction costs, charges owed for repairs, utilities, and so on. The property code specifies that you have to give a 3-day notice unless your lease specifies a different time frame. The Texas Realtors lease specifies a 1-day notice. We still give 3 days, actually. In many cases, the landlord can proceed with eviction even if the tenant then pays rent in full, so that is good to know. And as mentioned, landlords win the vast majority of eviction cases. Now let's turn to evictions during COVID. The guidelines vary depending on whether they're federal, state, county, or city, and they change over time. Something that's been the case since the CARES Act passed is that the property can't have a federally backed mortgage or participate in a federal housing program such as Section 8. But if you don't have that, your ability to evict will likely depend on your county or city. In Travis County, and right now, the eviction moratorium goes to April 1st, and that means you can't evict for non-payment of rent, but you can evict for certain other reasons. For example, if there was criminal activity at the property. Austin has been very tenant friendly, so they may extend the moratorium. Williamson County does allow evictions for non-payment of rent. In fact, we had a successful eviction last month in Williamson County. A potential wrinkle to all of this is the CDC moratorium. It says you can't evict for non-payment of rent if the tenant makes a declaration using a particular CDC form. The moratorium and the declaration only cover non-payment of rent due to COVID, so you can evict for other reasons. You also don't have to tell your tenant that this declaration exists. However, the court probably will. And the declaration can happen before, during, or after the court proceeding. The only deadline is before you gain possession of the property. So this can be frustrating, right? I learned that one interpretation of the CDC moratorium is that you can file the eviction and even get a judgment, but you can't file a writ of possession. In other words, you can't send a constable to remove the tenants during the moratorium. You may also be able to contest a CDC declaration, and it's probably worth trying. By the way, in February, a federal judge in Texas ruled the moratorium to be unconstitutional, and that is now being appealed by the federal government, so we'll see. But it may mean you could evict and argue in court that the CDC moratorium doesn't apply because a judge found it to be unconstitutional. That said, the district courts tend to follow what the Texas Supreme Court does, and it has not ruled that it's unconstitutional. So this ruling may or may not have any practical effect at this time. Also, the American Rescue Plan does not include an extension of the CDC moratorium, which runs out March 31st. So it's not actually clear what is going to happen after that. Remember at the beginning of this webinar, I said that there are rights and then there's doing what's effective or expedient. I'm going to give you a really interesting example that happened to us. We approved a qualified tenant for a home. Let's call him Norman. And the move-in date was March 15th, 2020. We went into COVID lockdown less than 2 weeks after that. And the very next month, the tenant told us he had lost his job and couldn't pay rent due to COVID. However, this didn't make sense because Norman was in the military and he wouldn't have lost his job or income. And the person who called could barely speak English, but Norman's English was quite good. Come to find out, Norman had rented the place for his illegal immigrant in-laws, and he wasn't even living there. Certainly this is fraud and it's grounds for eviction, and we certainly could have easily kicked the tenants out, but it would have meant our client had a vacant unit again so soon after renting it. Plus it was COVID and leasing had fallen off a cliff for the time being, so it wasn't clear what could be accomplished, and it certainly didn't feel humane. So what we did was we actually qualified Norman's in-laws and we put them on the lease, but we didn't take Norman off the lease so that he would still be responsible. Plus, we made it clear that rent had to be paid. Otherwise, Norman would be in a whole world of trouble if his CO were to find out, because the military doesn't take kindly to their members committing fraud. And we have always received full rent paid on time ever since. Okay. The next two slides, we're going to talk about some interesting rights that landlords have, although I don't necessarily recommend exercising these rights as they may be more pain than they're worth. So, as a general rule, you can't lock a tenant out of their home, but believe it or not, there are instances where you may lock them out. But it's sort of a fake lockout, and you can see if this is something you would even want to do. So these are the conditions that must be met. First off, the lease has to specify that the landlord may change locks due to tenants not paying rent on time. The Texas Realtors lease does not specify this, so this is not an option for those of us who use it. There are specific rules around giving the tenant notice that you are going to change the locks. In other words, you have to let them know ahead of time that you're going to do it. You have to leave a letter on their front door stating where the tenant can go to get a key 24 hours a day, or else a phone number that is answered 24 hours a day, and the tenant will be able to get a key delivered within 2 hours. The landlord must then provide a key regardless of whether the tenant has paid any of the rent. There are all sorts of other details, but those are the biggies. If you ask me, it seems like it's more trouble than it's worth, and the tenant gets the key in the end anyway. But maybe it scares the tenant? Who knows? The other interesting right is the landlord's lien, and unlike lockouts, this is in the Texas Realtors lease. I've never heard of anyone using this, but it's interesting and you could. The residential landlord's lien refers to Chapter 54 of the Property Code. It allows the landlord to remove non-exempt property, and then the code goes on to specify 15 kinds of exempt property. That is property you're not allowed to take, such as clothes, books, photos, beds, one couch, 2 living room chairs, a dining room table and chairs. So if they have 2 couches, you can take 1 of them. And if they have 4 living room chairs, you can take 2 of them. You can't take food or medicine, and you have to leave 1 car and 1 truck, but if they have more than that, you could take it. Like with lockouts, there are certain conditions that must be met. The property has to be abandoned, or if not, seizure must be authorized in the lease, and it can be accomplished without a breach of the peace. As mentioned, this is allowed in the Texas Realtors lease. And you must leave a written notice in the property indicating what has been seized. Okay, that is the main material I wanted to cover today. We'll have a Q&A in just a couple of minutes, but I want to briefly tell you about our Realtor Referral Program. This is a robust program that we offer to you. We get a lot of referrals from realtors, and this is our way of giving back. So when you think of a referral program, you think of fees, and yes, we give fees. And the more properties you send our way, the more fees you get. It goes by the number of doors. And there are 3 different tiers. So at the top tier, that's where you send over a client for full property management, and we're going to handle the initial leasing as well. The next tier is where you send a full property management client, but you are going to do the initial leasing. Maybe you offer it as a gift, or your client requests that you do it. Then the 3rd tier is a landlord who's going to manage the property on their own, but they want help with the leasing. And so we do quite a bit of that as well. We also offer a free analysis and review. And please understand that we offer this service to you whether or not your client hires us. It is not dependent on that. So what's great is, in a sense, your client is getting 2 realtors for the price of one. And that makes you look like a champ. We'll evaluate the home to see if it will make a good rental. Not every home does make a good rental. We'll also run comps. I know you can run comps, but how great is that for your clients if you have 2 realtors running comps, and then you can very confidently present the rent you think that they can get. In addition, we will make property visits. That is something I have done with clients that have had properties under contract, and they just want to, us to make a property visit while it's still under option to see if they should move forward with it. We also are just a resource to you, whether or not you're working with a client. I have realtors reach out to me on a pretty regular basis, and they just have questions relating to property management or rental investing, and I'm happy to answer any questions and help in any way that I can. We also offer the rental report. This is a monthly newsletter. It is for realtors. It is completely free, and it is specific to rentals. And it's to position you as an expert to your clients. And Allison, I think, has just put that link in the chat box, so you're welcome to sign up for that. And then we also offer these webinars, also completely free. And we're going to go ahead and actually put up our next poll, which is a bunch of topics. Please check as many topics as are of interest to you, and that will influence which topics we do future webinars on. And this too, the idea is to help you position yourself as an expert with your clients. So we'll go ahead with that poll. You're also welcome to, reach out to me if there are other topics not mentioned here that you would like us to cover. All right, we'll wait just another couple of seconds. Got a few more people chiming in. Okay, I'll share the results with you guys so you can see. And I'm going to take a screenshot of that. So great, thank you very much. This is helpful. Now, last, and maybe most important of all, we offer peace of mind to you. I'm well aware that realtors can be nervous about sending their clients to a property manager because you know that we're realtors too, and maybe you're afraid that we're going to steal your clients. But I am here to reassure you that that will never happen. I do property management. I don't do sales, actually. In addition, as I mentioned, we get a lot of our referrals from realtors. I would never, ever want to, muck with that relationship or bite the hand that feeds me. That just isn't something I would do. So realtors can always rest assured that we will send your clients back to you when they are ready to sell. In fact, we have about 10 clients who are taking advantage of this crazy seller's market to sell properties, and I am not the realtor for a single one of those. Allison is going to go ahead. I think she did just put my contact information in the chat box, and you should feel free to reach out to me if I can help you in any way. All right, we're going to go ahead and move on to the Q&A portion. I'm going to take a look at questions in the chat, and then beyond that, if people want to unmute themselves and ask questions, then you'll be welcome to. Okay. So the first question is, for support animals, can you require a tenant upon exiting to have them do a full house steam cleaning? So absolutely. Just like with children, anybody who is, whether it's an animal or a human who's living in the property, you're responsible for those people. So so you can require them to clean. You can sorry, I don't know why I'm blanking, but you can take money from their security deposit as needed. So support animals, you can't. They're not considered pets and there's no pet deposit, but otherwise you absolutely, the tenants are responsible for the condition of the home. What counties do we manage? We manage, that's a great question. We manage Travis, Williamson, and Hayes County. Okay, and so somebody is requesting us to repost links in the chat. And so, yeah, sure, absolutely happy to do that. So the links would be, we'll post for the property code and the Texas A&M Landlords and Tenants Guide, and then we can put our contact information in here, and then also the evictions section of the property code. Okay, do we have any other questions?
Yeah, I have one.
Great.
Hello, can you hear me?
I sure can.
Yeah, I'm on my iPhone. So anyway, yeah, my question is how are repairs handled? Say we have a house that we want you to manage, and say that the client or the owner wants to be able to handle some of the repairs on their own as they can. So just wondering about that, how those are handled.
Well, so that would be really, there's no hard and fast rules about that. So we don't allow our owners to make repairs. And the reason that we don't is that we actually want to make sure that we're only working with really qualified, insured vendors who know what they're doing and are going to get the job done right. In the past, we had allowed owners to do some repairs, and surprisingly, it was always like a complete disaster. And I'm not joking. I have several examples of it just being a complete disaster. And so, we do it to make sure that, quality of standards are being met. And also the other thing is that it gets harder to, you don't actually want especially if it's if there are tenants in place, you don't ideally want the tenants to know who the landlords are. You don't want them to have contact. It's a way, like by having a property manager, it's a way to protect the landlord from their tenants. And so if the landlord's doing repairs, then the tenants may start going to the landlord for issues. And that actually makes it much harder for the property management company to actually know what's going on, to stay in the loop, to sort of manage the property effectively. So it's up to, the property manager or the landlord, but I definitely don't recommend it. Any other questions?
Thank you.
You're welcome.
I put one in the chat. If you have a tenant that has been late many times, but then eventually they catch up with their payments, how do you feel, or when's the right time to give up on the headache of knowing that they're probably going to be late again? But then again, if you try to evict them, it seems like they'll just make their payment on time.
So yeah, so this is definitely very much like a case-by-case situation. And we make different decisions depending on the situation. So do you have a specific case in mind, or is this a general question?
I have a tenant like that.
So they just eventually get themselves paid up, or you threaten them and then they get paid up? Like, how does it go?
Well, we had threatened eviction several times in the past, but then in the past year it wasn't as bad as the previous year. So they're still with us and they're all caught up currently, but they're very frequent to be late, like almost every month.
When does their lease end?
June.
If it were me, I would probably just wait until June in that case, if they do in fact get themselves caught up. That's likely what I would do. And then I just wouldn't renew them, because it's like a headache and you're spending a lot of time and energy on a tenant in that case. And if I have the option to get a better tenant in place, because the thing is with evictions, what county are you in?
Williamson.
Oh, in Williamson. Well, so you can evict for non-payment of rent. It's also a question of like whether you want to pay the fees and you want to go through that process. So if you go through that process, maybe you would get them out a month or so, maybe 2 months earlier than if you just wait till their lease ends. And so that's really a personal decision about what your tolerance is, and if you think it will be worth it, and how you think you might more effectively get the rent. Let me say too, let me add that there is, from the last, or from the American, I can't remember if I think it's the American Rescue Plan, or maybe the plan right before that, there is rent relief. And I think it's, if you go to texasrentrelief.org or com or something like that, you can actually apply on behalf of your tenants. Your tenants have to then sign their, they have to sign as well. But then you'll be able to get relief from, so that it was a federal thing, but it was distributed to the states. And so
that would actually sounds like more headache though.
I don't think so. I don't think that's a big headache. It's an online form. You fill it out and then the tenant gets notified and then they have to sign, and then it goes into a process.
I don't want to be worrying about them getting their payment. That's their responsibility to make their payments on time.
So fair enough. Then that's completely up to you. For us as property managers, my goal is to get rent for my clients, and I'll do it however I can. But that's
given that the lease is up in June, at first you sounded like it's best to just wait till then, which sounds like a good idea to me. But when the lease is up, there's still some dangers there. If they didn't want to leave and their lease is up, then they could still cause more headaches, right?
That is definitely true. Most tenants don't hold over, but at that point, certainly you can evict them for doing a holdover. You would want to consult an attorney, but I have had experience with this, so you're welcome to reach out to me at different stages, like, hey, this is where we are now. What do you recommend? I'm happy to share my opinion. But for right now, I mean, if it were me, I would seek the rent relief, and I would wait until the lease was over and then just not renew it.
Okay, thank you.
You're welcome. Okay, any other questions? Let me see if we have any others in the chat.
Well, I have one if you don't have one in the chat.
Go ahead.
So how often do you do like the inspections, and are they surprise inspections? How do you handle those?
So we
Even if you don't, let me add something to that. Say you don't even suspect that there's something going on. Just, you know, I had a tenant here a year, and I think it's just, you know, a reasonable time to do an inspection. What does that look like?
Yeah, so we do inspections every year. We don't renew tenants without an inspection. That's how we determine whether or not they qualify to be renewed. And it's not a surprise inspection. We actually use a third-party company. They provide a report. It kind of looks like a professional inspector's report, but it's not. They're not professional inspectors. They are inspectors specifically for property management. And then they go in and they, you know, they look at a lot of the same things that professional inspectors do, but not everything. They don't look at all of the major systems. They're not going to get on the roof. They're not going to check your appliances, but they take photographs. And they are also at the same time, they're looking to see, is there evidence of pets? Is there damage being done? So that helps the landlord know, like, is there regular repairs that need to be done, and as well as the tenant damaging it. So that's how we handle it. You certainly could do a surprise inspection. I think some people do. One of the things that, you know, we really work hard on is that balance between, you know, doing what we have to do and being like a pest or engendering potentially ill will. So obviously tenants aren't going to be psyched if you're doing these surprise inspections, but we're really looking more for, you know, like tenants who just don't take care of the property. Like chances are they're not going to be able to hide that even if they know you're coming to do an inspection. Does that answer your question, or do you have any follow-ups on that?
Yeah, kind of a follow-up. So once it's on a month-to-month, which we have one that's on a month-to-month, and it's been like that for a while. How does that work out? I know you said at renewal time, which I understand, but how does the month-to-month inspection work? Is it still on the year?
Well, that would really, I mean, that would 100% be up to do. I mean, you could do inspections every quarter if you wanted to, you know what I mean? Like you don't have to give notice. You really can do it based on whatever schedule you want. So if you feel like it's time for you to get in there, you haven't been in there a while, you can absolutely go ahead and do that.
Okay, thank you.
You're welcome. Anyone else?
I have a question.
Yeah.
On for the default and eviction, it says property code specifies giving 3-day notice unless specifies otherwise. Is that you can evict in 3 days? And then it says that the TSR 201 specifies 1 day notice. Is that to evict?
That's to a notice to vacate. So that you would just literally, like, you would post a notice inside their front door that they have to be out. So it's a process. Eviction is a process. So first you just try to like get them out on your own, and you're required to post this notice. And so on the notice, it tells them how many days they have to leave. And you can, and the Texas Realtors lease only requires the 1 day. The property code, if it's not in the lease, says you have to give 3 days. Some people give longer because, you know, people have a lot of stuff. Maybe it's hard for them to get up, and it's just, that part's up to you. It's only then, like if they don't leave, then you would file in court, and then you have to wait for a court date. So that whole process is going to take longer. Does that make sense?
Okay. Yes, because yes, that clarified it. But also I wanted to find out how many days after the rent is late can you do this?
You can do it. Okay. I'm trying to remember. So like with late fees, that's a good question. It's either 1 or 2 days after, like if you have a grace period, you'd have to wait for your grace period to be over. But I think it's either 1 or 2 days. I can actually look that up for you.
Okay.
Yeah, I mean, I can't do it right this second, but if you put your contact information, if you put it in the chat, then I can let you know.
Okay, thank you.
You're welcome. All right, who else?
Well, I have another one. If no one else, I don't want to take up all your time, but if no one else has one, I have just a question, comment, I guess.
Sure.
Yeah, so we have a property that we're thinking about leasing. How do I get in contact with you to get more information? Do I just reach out to you, or we're out in Driftwood? So I know you said you do Hayes County, correct?
Mhm. Yeah. So you can reach out. Allison, would you mind putting the contact information in the chat one more time? So she'll put my email address. Actually, is it mine? Or is it our, yeah, it's my email address and our phone number, which is right here as well. Tell me who you are so I can expect your call.
Mary Salcedo.
Mary?
Yes.
Okay. Okay. I did see.
And I'm Ayana. I'm the one who sent you my information in regards to the question of how many days after the rent is paid can you post a notice.
Okay, great. Great. Thank you. I do see somebody in the chat has asked about our fees. We charge 8% is the monthly management fee. If somebody comes to us with more than one property, then it's 7%. Okay, I do see some other questions. How do you feel about not participating in the rents program? The money goes to tenant and the tenant pays, is my understanding. Actually, the money with the rent relief program, the tenant signs it and the rent, I believe, actually comes to the landlord. I'm almost positive that that's the case. Oh no, in fact, I know it because we have received checks. Oh no, I take it back. That's a different program. We've received money for tenants on maybe a Travis County program. I'm almost positive in the case where we apply on their behalf and the tenant okays it, that the rent comes to us. Even if it doesn't, it's still better. You have a greater chance of getting your rent if somebody's getting the rent than if you haven't applied at all. That would be my perspective on it. Okay, Mark asked, where can we find the notice to vacate? So it is, I don't know the TXR number offhand, but it's called like notice terminating right of occupancy or something like that.
Landlord's notice not to renew.
That's a different one. That's like if you're, yeah, so notice, I'm assuming notice to vacate means like if they haven't paid their rent and you want to start the eviction process, then that would be the notice to vacate, which is called notice terminating right of occupancy. And then you're right, if you're not going to renew their lease. All right, who else has questions?
I have a question.
Abigail, it's,
You go
hi,
ahead.
Dominique. This is Stacy, and I've got to hop off. But before I do, I wanted to say thank you for doing this. And then I wanted to reassure every realtor on this call that Abigail does return your client to you. I know this because I've just experienced it. She called me and said, hey, so-and-so wants to sell and take advantage of the market. And even through the sale of the transaction, she's been fantastic. So she has zero interest in selling and representing buyers in this craziness that we're living in. So yeah, she's just a woman of her word. So thank you.
Thanks, Stacy. Thanks very much. I appreciate that. Okay, I heard someone else.
Yes, I have a question. My name is Dominique. So do you find that owners ever will price up their, like you said, your fees are 8%. Do you find any owners that are sort of pricing up their leases, maybe 5 or 6% more, a little bit more than market value to sort of to work that price into the bucket, so to speak? Do you have, it seems like it's such a crazy time and such a need for properties that their prices are going up anyway. Do you find that owners are doing that?
So the answer is no. And the reason, there's actually two reasons, but the first reason is that we actually don't consult our owners on the rent. We believe, just as, we're actually authorized. So unlike realtors with sales, you have to ask your clients, you can't make decisions on their behalf.
Right.
We actually can. We are authorized to make decisions on their behalf. And so we actually determine what the rent is, and it is based on the market.
Okay.
So no, it doesn't work that way. And then the
Okay,
other
you just
reason
get
is
the median, you just, when you do the CMA, you just go right for that median price.
I will always try to get the most rent that I think I can get, and I pay very close attention to my listing. So I will
Okay.
adjust as needed. But the market will bear what the market will bear, right? So it doesn't make
Yeah.
sense to just to tack on rent without there being a reason for it.
Okay,
Yeah.
okay. Because it sounds to me like with a management company like yours, you're just getting sort of extra quality, it sounds like. So I thought that there might be a way to nudge that price a little up, but that seems it seems fair the way you're speaking about it. Thank you.
You're welcome. So something I do want to say is that, yes, property management is an expense, but something that people don't realize is that we can actually save owners money in other ways. Like we legitimately can, and that will offset some of the costs of property management. Maybe not all. I've never actually sort of fully calculated that out. But for example, typically we can get more rent than self-managing landlords can get. Typically, for example, we will protest property taxes on behalf of our clients. We don't do it ourselves. We work with a third-party company. And so a lot of people won't bother to do that themselves. So that just the fact that we say, hey, tell us yes or no, and we'll do it, like that's a benefit to them right there. In addition, we get a bulk discount with the third-party company. So they're getting a better deal going through us than they could get on their own. So they do save money that way, as long as their appraisal is lowered. Oftentimes we get better deals with our vendors because we use them all the time. We have better relationships. Another way relating to repairs is, let's say with the Texas storm, maybe the average landlord, it took them a couple days or a week to get somebody out. We had all of our properties being handled like during the storm and the day after the thaw. And so that can actually, the longer a repair, sometimes the longer an issue goes, the more expensive it is to repair it. And so we save them money by being able to get in there. So I think it is important to understand that, yes, there are costs, but there are actually legitimate savings as well. Okay, any other questions? I'll check the chat box once again. Okay, last call for questions. There aren't any others in the chat box. Going once.
You do property management for a home that's rented out by the room?
We don't. We would only, like, everybody who lives in a property is on one lease and they're all responsible to the lease.
Okay.
Yeah. Anyone else? Last call? Really last call? All right. Thank you guys so much for joining. It has been my pleasure to present this to you. As I mentioned, please feel free to reach out to me with any questions relating to property management, whether it's for your clients or even for yourself, rental investing. It's really my pleasure to help wherever I can. This is like, sales is not my forte, and I have realtors I reach out to when when maybe my clients have questions about that, but I know a lot of folks don't necessarily know property management. So any way that I can help, please, please feel free to reach out. Otherwise, have a wonderful day. Enjoy this gorgeous, gorgeous weather. And thanks again. Bye.
Thank you. Thank you.
Thanks, Allison. Thanks, Angel. I really appreciate it. It went very smoothly. At least that's my impression. And oh, I'm gonna stop recording.